So can your visitation schedule be modified? Let's say you've gone to court, a judge has made orders regarding what your visitation schedule with the children is going to be, or maybe you and your spouse have agreed at mediation on what the schedule is going to be, and that gets incorporated into your final divorce decree. Can you ever go back to court and change it? The answer to that question is yes. Circumstances often change after a divorce. Children's preferences may change as they get older. The relationship between the parent and child may evolve as the years go by. And you can file what's called a modification suit and take the other parent back to court to have that schedule changed. In order to prevail in a modification suit, you have to demonstrate to the court that there's been what's called a material and substantial change since when the previous order was entered. So if your divorce decree was entered in, let's say, 2017, and we're now in 2023, if there's been a significant change in circumstances, a material and significant change in circumstances, then you can petition the court to modify your possession schedule. So what are some examples of some things that might change in the intervening years? Well, your child may be older. Maybe your child was 7 at the time that the original order was entered, your divorce decree was entered, and now the child is 12 and has indicated that he or she wants to go live with you. That would be an example of a material and substantial change that would justify you at least petitioning the court and asking the court to change your schedule. Now, does that mean a judge is going to necessarily conclude that it's in the child's best interest to change the schedule? No. But that's an example of a change in circumstance that would warrant you filing a modification suit, assuming you want to change your schedule. Let's say your ex-spouse, your ex-wife, your ex-husband has remarried, and that person has a criminal record, or that new spouse has been abusive to your child. That would be an example of a change in circumstance that may justify you filing a modification suit and changing that schedule. Another common change in circumstance is if somebody gets a new job or needs to move, they're called relocation cases, then you'd have to go to court and petition the court to change the existing geographic restriction in your decree. Most decrees, most final custody orders, with respect to the primary parent, they delineate a geographic area in which the child has to live. If you're the primary parent, let's say, and you're restricted geographically to Travis and counties that are contiguous with Travis County, which is kind of the standard for what courts generally order for the primary parent, and you want to move to Dallas or you want to move to another state, then you'd have to file a modification suit and petition the court to expand that geographic restriction to include whatever area you want to move to. Now, I'll say that relocation cases are very challenging, very difficult. For cases like that, I often encourage clients to consider a jury trial, because juries can decide what that geographic restriction is going to be. They can lift it, they can expand it. That is a question that can be submitted to a jury as opposed to a judge. And I would say that in my experience, judges are generally speaking, not always, it depends on the facts, but generally speaking, they're a little more hostile to letting children move than juries are. So there's a lot of other things that I probably left out as far as what circumstances may justify a change in the schedule, but children getting older, change in preferences, other family members that are introduced to the household, a new wife, a new spouse, maybe that person has other children and there's conflict or there's issues at home, or a parent develops a drug or alcohol problem, or there's a mental health issue that's impacting the parent's relationship with the child. Those are all examples of circumstances that may arise after your divorce decree is entered that would justify you coming to court and asking the court to make a change.